4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Well, as the promo says, it is a very good morning to Andrew Bell from Bell and Senior Lawyers. How are you?
I'm wonderful. Thank you for having me back.
You're very welcome. Well, this is your opportunity to get some free legal advice live on the radio. Andrew is standing by for your call this morning on 0755 208888. Do not leave your question or your call too late in the program, otherwise you may not get to speak to him. So dive for that phone now. We've got our first caller. We might start right there. It is a very good morning to Helen. Helen, ask your question of Andrew.
Oh, thank you very much. Yes, Andrew. Yes, look, I'm just inquiring. We've got a boarder that lives downstairs, and a friend of mine told me that if they've been there for at least 2 years, they can claim half of your house. Now, can you please tell me if this is wrong or right?
That doesn't sound correct to me, Helen. I thought you were going to say, do you need to have them registered with the RTA, or do you have issues with getting rid of them if you want to? Because those are rights that attach depending on how long someone's been there, even if they don't have a formal agreement. But in Queensland, if your name's on the title, you own the property. There are some special conditions around 12 years. If you treat a property like your own exclusively, then you may be able to put a claim into the Supreme Court, but that's a very rare scenario. But there's nothing that I'm aware of that would say that a boarder, if they've been there for any amount of time, if you're also there, has any rights over the property. Oh,
right, okay, because we've known this guy for about 20-odd years. Mm-hmm. And he's only, because he was normally living in Sydney, and then he come up here, and he's been up here he's been living downstairs for about 14 months, and I'm just, and that got me a bit worried, when this friend told me. She said, she said they can claim, half your house if they've been living there for 2 years, and I thought that doesn't seem right to me.
2 years and half property may be coming from de facto relationships, where if you're in a relationship with someone for 2 years, they have the right potentially to put in a family property division claim at the end of a relationship, but there's nothing that I know of that would give property rights to a boarder for any period of time.
And she was saying, she said that you can get a form or something and get him to sign it to say that he's not going to do anything like that. But I don't know. That seems a bit too over the top. I don't know.
That sounds over the top to me. A lot of people do move to having a formalised rental agreement that talks about when they could get rid of someone, because otherwise, if you do try and get rid of them and there is no formal agreement, they may come back later and say, no, they're violating and I'm supposed to be here for X number of years, and it might be difficult to kick them out. But in terms of any ownership interest over your property, a boarder living there for 2 years, there's nothing I'm aware of that would give them any sort of proprietary right. As I said, adverse possession, which is 12 years, is the only thing I'm aware of in Queensland, and a boarder wouldn't meet that criteria.
And I live in New South Wales. I live near Tweed Head, so...
Okay, but I am also unaware of anything where a boarder would get any proprietary rights after any period in Australia.
Okay, so you're saying that I shouldn't have anything to worry about?
As I said, no, not on the ownership front, but if you don't have a formal rental agreement, I'd consider getting one.
Yeah, well, it's not really. Well, we're classing, and he classes himself as a boarder, so I don't know if that's the same as renting or not.
Helen, is he paying you rent?
Yes, he does. He pays us $100 a week.
So that would probably formalise an arrangement, even though you haven't got the documentation. Andrew is the expert, but I'll leave it to you to clarify, Andrew.
Absolutely, yes. I would, if there was $100 a week, just put that formally, so then if it doesn't get paid or there's any other issues, then you have some sort of a recourse. And last week we were talking about QCAT. Since you're on the border, you'd be going to something called NCAT at the Tweedhead Magistrates Court if you need to have anything there. But as I said, the 2 years doesn't apply. There is no border rights in New South Wales or Queensland to own your property.
Okay, then. Thanks very much for that anyway.
Thank you, Helen.
Thank you, Helen. All right, if you'd like to ask a question just like Helen has this morning, all you need to do is give us a call. 0755 208888 is the number. And as I said, do not leave it too late in the program. Now, the topic of the day, we are going to be talking Gold Coast property. A complete guide for buyers and sellers this morning. If we can get to the bottom of it, might carry over till next week if we get a few phone calls. So, Andrew, I'm going to let you give us a précis.
Well, thank you, Colin. Well, one of the reasons why I thought this might be a good topic for us to discuss today is that property law in Queensland has changed significantly over the last few years. It's nowhere near as simple as it used to be. Governments have tried to put in protections and they've overhauled the Property Law Act of 1974 to 2023, but it only went into effect last year. And at the same time, Gold Coast properties transformed itself a lot. So the Gold Coast just overtaken Sydney as the most expensive unit market in Australia. House prices are now averaging 1.32 million. And at the same time, the new rules have significant deadlines. There's stakes for getting things wrong. And the way that you thought that you could sell a house probably isn't the way that you can actually sell a house today. So we're going to go through what sellers need to disclose, and that's something that happens before a contract's signed. We'll look at the legal risks of buying off the plan and what happens if a property deal falls apart. And we'll also answer a question we get constantly: do you need a solicitor or is a conveyancer enough?
Perfect. Well, how about we start with painting us a picture of the Gold Coast property market right now?
Yeah, so the repricing has happened. There's been significant appreciation of values over the last few years. So a lot of people are considering selling or locking in those gains or looking to buy somewhere different. The median house price is $956,000, which is more than $927,000 in Sydney. So it's the first time in history that our property price is more than our southern neighbours. Median house prices, as I said, were 1.32 million, and certain pockets, particularly on the beachfront and on the waterfront, are going well above that figure. Analysts were predicting a 7 to 11% price growth this year, but I can't give financial advice. But the experts say that it's underpinned by persistent housing supply shortages and the Brisbane 32 Olympic Games.
Okay, well, are all parts of the Gold Coast performing equally, Andrew?
No, they're not. It depends how far out you are, essentially. Ashmore and Robina are seeing very strong growth. Mermaid Beach and Broadbeach Waters and Hope Island have shown some softening, but they are looking at potentially many homes over the $3 million mark. Oh, sorry, I lost my place. What I was going to talk about, though, was seller disclosure after that. So
okay. And there is a new seller disclosure form. What has fundamentally changed for sellers since August of last year?
So previously, Queensland operated under a scheme called Buyer Beware. That meant that the buyers had to be responsible for all searches, etc., on their property before they were able to purchase it, and if they didn't raise things in the contracted period, then they had to live with what they got. Now, this significantly changed on the 1st of August last year, where the Property Law Act came into force. And the biggest piece of that, modelled on some Victorian legislation, is the mandatory seller disclosure scheme, which is called a Form 2. Now, this requires every seller of residential, commercial or vacant land to prepare what's called a Form 2 seller disclosure statement and provide it to the buyer before the buyer signs the contract. So they must see it before they've signed it. Similarly, the buyer must have received and had the opportunity to read the disclosure statement before any contract comes into existence. So the Form 2 covers a lot of different bits and pieces, but what is important is that timing aspect of things, Colin. So
So let's just get that one right and break it down. Prior to this change in August of last year, it was let the buyer beware. You have to do all of your own searches on the property that you're about to purchase. Now the seller has to prepare all of those searches and provide that in advance of a contract being signed or even being reviewed.
Exactly. So previously the real estate agent could prepare a contract, have it signed and present it to you whether you wanted to do something. Now you have a positive obligation to create this Form 2 beforehand.
Okay.
Now the Form 2 doesn't cover everything. The Form 2, unfortunately, if you're a buyer, doesn't include things like the structural soundness of the property, the flooding history, pest infestations, known building defects. It's more about searches around body corporate, whether there's easements on the property, the title to the property, zoning classifications of the property.
Flooding maps, all of those type of things,
No,
I would imagine.
flooding map isn't covered.
Okay,
So it's more technical things around the ownership of the property and what's going to change. Now, the Form 2 can't be rectified once you've created it. So if there are any problems on that Form 2, and then the buyer can cancel the contract with no penalty at any time up to and including settlement.
Okay, so there is the difference. You've got to get it right if you're selling the property, otherwise the buyer has an out clause. Is that what you're basically saying?
Absolutely, and this is being shown to being used to negotiate very heavily, and none of it has been tested in the courts so far, so there are significant risks. For example, if you've sold the property and then the buyer cancels, do you still need to pay the real estate agent even though you couldn't keep the deposit and you haven't actually sold the property? The Form 2 must be right or they can cancel at any point in time. And as I said, it needs to be prepared before you present a contract to the potential buyer for signing. So it means that you actually need a relationship with your lawyer or whoever's preparing that Form 2 before it's even put on the market.
There you go. So very big changes. Well, we might just say that we're halfway through the program. This is a talkback program and we do love hearing your questions. Doesn't have to be property related, but it does have to be legal related. You can give us a call right now, 0755 208888. Do not leave your question to the very end of the program. We usually run into a bit of a bottleneck there and you may not get your question answered today. All right, so we've covered off what the Form 2 actually covers. And we've run through what it doesn't cover, and those two don't cover it. It's pest and building, right, that we really need to be looking at that the Form 2 doesn't cover.
Absolutely. And potentially on reviewing the Form 2 information, you may want to do other things, other standard reports, whether it's rate searches, etc. So the Form 2 gives you some disclosure, but the buyers are still going to have to do their own disclosure.
Sure.
Our insurance recommends that our client redo all the searches that are in the Form 2 to make sure that the Form 2 provided is actually correct.
Wow.
So we've added cost to the seller to perform these Form 2 searches. We're now adding cost to the buyers to potentially redo them again. So it's very important to understand what your obligations are and also that this may slow down any sale that you're planning, including an auction.
Yeah, it's interesting. So we go from buyer beware. Basically, you've got to do all the due diligence to make sure that what you're buying is a good deal in your eyes. And to now the seller has to provide a ton of information in this Form 2 to say, well, this is what you're actually buying. And if they get it wrong, they're the ones who actually get left holding the bag. Is that right?
That's correct. Now, the point of it was so people would be better informed before they sign their contract. And we have seen in instances where people have been buying into a body corporate, where that body corporate owes a lot of money and there's going to be a large bill coming down the future that they may not have been aware of or been able to negotiate before they entered the contract. Or similarly, Coomera Connector, land around there, people were selling things and it may not have been immediately obvious that some of that land was either going to be reclaimed or be right next to a main road that doesn't exist at the moment.
Yeah, that's very interesting, isn't it? All right, we've got our second caller of the morning. It is a very good morning to Beryl. Beryl, ask your question of Andrew.
Oh, thank you. Good morning. When purchasing a property and you exchange contracts, you are required in Queensland to take out insurance on that particular property, and yet the seller who is selling the property still has to have the property insured as well. Isn't this a little bit of double dipping?
Well, these aren't necessarily requirements. These are more risk management activities. So the moment that you sign a contract and intend to purchase it, then the liability for any damage goes to the buyer. So it's prudent to have insurance in case that house that you're buying and want to move into burns down. There is no legal requirement that I'm aware of to have insurance on any property from either party. It just depends on the risk that you're taking. If you're selling your property, I wouldn't advise you to cancel the insurance until the very last minute because, say, there was a defect in the Form 2 we were just talking about and the buyer cancels with limited notice, you may be left holding the bag for a property that needs to be fixed as part of insurance. So while the insurers may be benefiting from that extra period in time, it's more up to the buyer and the seller to decide what level of risk they're comfortable with.
But this only happens in Queensland, though, I believe.
I think this is imported from the common law and applies across most common law jurisdictions in Australia and overseas, that once the seller has signed the contract, they assume liability for what they're purchasing.
Yeah, it's an interesting one, Beryl, having seen a couple of problems in between, and it ends up being a legal fight. The property a friend of mine was purchasing, the owner couldn't afford insurance, so didn't have any. And so he just assumed that they did, and there was a problem. A car smashed through the fences, and after he'd purchased it, he was liable for the fence repairs. But there was legal wranglings in between because he didn't understand the rules and didn't realise that the previous owner didn't have any insurance either.
My understanding is the Queensland storms that we recently had as well, with a lot of people buying properties over the Christmas breaks. There was a lot of damage in the Helensvale and surrounding areas that were resolved with these sorts of insurance issues.
So you're just protecting yourself, Beryl?
That sounds all right then. Okay.
All right. Thank you, Beryl. All right. We're moving on to Rod. Rod, good morning to you. Ask your question of Andrew.
Yeah, good morning, guys, and happy Tuesday. Andrew, Col, I've just walked in and I heard Form 2 mentioned. My question is, if you go to auction your house,
yep,
have you got to go through and do a building and pest and do the Form 2 and everything else as well, or does it alleviate all that?
So again, the Form 2 doesn't cover building and pest. If you are doing an auction, you need to provide the Form 2 material available for anyone before they bid, so it's available to them to see. And similarly, at most auctions, the seller would have done a building and pest and made that form available as well before the auction. Because if you buy at auction, it is still buyer beware, and if there are building and pest issues, you take them on if you've purchased it at auction. There is no comeback period, unlike buying a house, where you typically have 14 to 21 days to get the building and pest done.
Okay, thank you so much. So it's just the Form 2 that has to be done even if you auction.
That's correct.
Correct.
Okay, guys. Thanks so much for that.
Good on you, Rod. All right, we're moving on to John. John, ask your question of Andrew.
Yeah, morning, Andrew. Thank you for giving us your time. We appreciate it.
No worries, John. How can I help today?
I'm just wondering if a solicitor is holding your will, your enduring power of attorney and your health directive, if you pass away, does he charge your family a fee for holding on to those documents?
That would depend on the individual agreement with the solicitor, but I think it would be uncommon for that to happen. We charge a very small fee to hold on for secure storage for those documents, and provided someone provides the correct identity documents to get a copy of them after someone passes, or if someone needs a copy of an EPOA, then I haven't ever charged and seen it charged, but that is something that would be in the agreement you signed with your lawyer when you did that.
Yes, no, well, my daughter has a certified agreement of the of my will and and my enduring. She has my enduring power of attorney,
Mm-hmm.
and she has my health directive. So she has legal copies of those in her possession.
So normally the certified copies are sufficient. If you need to go through probate for a will, someone will need a death certificate and the original copy to lodge with the Supreme Court, and they may need legal assistance to be able to do that. But as I said, normally with the right ID documents, I would expect that you would be able to get that from your solicitor without a charge. They're not being held ransom.
All right, and thank you again for giving us the time. We appreciate it. Thank you.
Thank you, John.
Good on you, John. Well, if you'd like to ask a question of Andrew from Bell and Senior Lawyers, you can give us a call right now. 0755 208888 is the number. Final 5 minutes in the program, and please call right now if you have a question. We are going to go to a message from our sponsor.
Wills, probate, powers of attorney or property matters. Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 5532 3133 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
Well, some great questions there from the listeners. Again, if you'd like to call in, now is the time. 0755 208888 is the number. Now, we had a great question there about auctions. Have we covered off what this new Form 2 does in the case of an auction?
I think so. So the Form 2, as I said, must be brought together beforehand with all the certificates attached. So QBCC searches, pool safety searches, titles, anything else that's in the prescribed list of forms. And then that also needs to be given to the successful bidder at the auction. And as I said, it applies whether it's vacant land, a unit, or a house.
Perfect. All right. Any practical tips for sellers getting ready to list?
I think we have someone.
Oh, we do. My apologies. So let's grab the call. It's a very good morning to Barbara. Barbara, ask your question of Andrew.
Good morning. Thank you.
Good morning.
Good morning. We've got a family property. It's an apartment on the Gold Coast. We've purchased about 5 years ago. There's some extreme drumming in the walls in the bathroom, all different times of the day and night. But sometimes it's so extreme that it's cracked the walls in the bathroom walls and through the light switches. We've mentioned and contacted Body Corporate regarding the situation to investigate, and they refuse to take any responsibility and sort of keep putting it back onto our shoulders and for us to do further investigations. Was there any advice in that area?
Normally, plumbing in a unit situation, again, it depends on the situation of where the plumbing's actually located and who put it in. Normal rules would be anything up to the walls is your responsibility. Anything inside the walls is typically the body corporate. So the body corporate is normally done for what's called common property plumbing, whereas your responsibility for utility infrastructure. So it would really depend on exactly which pipes were causing the issue as to who needs to investigate and bear the cost. A reasonable body corporate would normally, you could put them on notice that you're investigating this issue and that you'll be asking them to contribute if it turns out to be the common plumbing rather than your individual utility plumbing, and give them an opportunity to do the investigation to begin with. However, that is a bit of a tricky situation that would really depend on exactly which pipes it is and where they were located as to whether it's your responsibility or theirs.
Okay, so moving forward, what would you recommend for us to do?
Maybe the investigation to find out whether it is the plumbing's inside your building and not the common plumbing that takes, say, your sewage or your water into your apartment.
Yeah, so I would get the opinion of that from a plumber, and if they can answer that question, then that should then send you down the route whether you're going to be responsible or whether you need the body corporate to proceed.
And is there a specific plumber or experience that I need to look for?
Well, I'd ring them and ask them if they know how to differentiate between the two.
Okay, awesome.
All right. Well, thank you very much, Barbara. We're moving on now to Anthony. Good morning, Anthony. Ask your question of Andrew.
Good morning, Andrew.
Morning.
It's Anthony here. It's in relation to, I'm a local. I've lived here in my street for 28 years. I've attracted, unfortunately, some hostility from a neighbour within my street. He's posted on the Southport community page, which are derogative comments, which has escalated to, unfortunately, my oldest son. And then from there, he's put out a letter to all the neighbours in the street, basically defaming what's going on in this household. I've had the attention of the council. Hasn't been very nice. It's definitely disturbing my peace and quiet. I'm now not working anymore.
Well, that sounds very distressing.
It is very distressing. I've been to QPS twice. And they said I should go to the courthouse and lodge a disturbing the peace.
Yes, so you can apply for a peace and good behaviour order against someone, which means that they must adhere to that order based on, and then if they don't, then they'd actually be committing a criminal offence. Have you proceeded down that option?
I'm looking at that. I'm dealing with mental health as well, so it's difficult. I'm dealing with rentals around me where I live, and there's overgrown trees, and I've contacted the management about the trees, and it's just I just don't have the fighting will within my. But you guys deal with council matters, etc., like that.
Most lawyers do.
Yeah.
How can we help you today, though? What's your question, Anthony?
And I just need to know the sort of what sort of legal counsel I need to contact. I know there's the community legal aid, the people that help you, but if you guys deal with it as well, I just need to know. I've got that up my sleeve.
Anthony, can I ask you to just give the reception a call back after the show? I get the feeling that this is going to be a longer discussion, and Andrew will give you a call at his convenience after the show. How does that sound?
All right. Yeah, no, that's fine. Thanks. Hey, you guys are awesome. Thank you for your constructive and advisory advice. I really appreciate it.
Thank you.
Good on you. Thank you. Well, we've got one more caller. We're going to squeeze it in. Good morning to you, Val. Val, ask your question of Andrew.
Oh, good morning, Andrew.
Morning.
I bought a air conditioner from an electrical firm that installed it on the 9th of December. Now, on the 1st of April, I phoned and said, could someone come in and show me, the temperature to put it on? So the electrician came and showed me. But yesterday I received an email saying I have to pay $99. Now I'm wondering, I'm sure it would still be under warranty, and they didn't tell me it would cost me $99.
Look, I think they should have told you, but I don't think that would have classed as a warranty issue if you were just asking them to come out and show you how to program it. So a call-out fee would probably be reasonable in those circumstances, and $99 is probably reasonable given the amount that people are currently charging for those sorts of things. So I think in the future I would be asking the question, if you're asking a tradesperson to come out, will there be any fee associated with this? But because you weren't calling them for a defect and you were just asking for instructions on how to use it, I think it's probably a valid fee for them to charge you a call-out.
Okay, thank you so much.
Good on you,
Thank you, Val.
Thank you. All right, we're running up against local news and have run a little over. Andrew, thank you very much for your time this morning. Great program. We'll have to go into phase 2 of our property discussion next Tuesday morning at 9 o'clock. And if you've got any questions you might like to ask, or if you've got any more things you'd like to learn about the new Form 2 and ways of protecting yourself and your property, tune in next Tuesday at 9 o'clock.
Can't wait. Thank you, Colin. Speak to you then.
Thanks, Andrew.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.